yeah, with the ruling advocate.
Thank you so much. All right, I've received an explanatory affidavit from the second respondent. I've received yesterday an affidavit in response thereto from the applicant. I've not yet seen an affidavit from the first respondent. Mr. Creer, can you please advise?
The first respondent elected not to file an affidavit in response to the affidavit filed by the secretary.
Okay, that's fine then. All right, Mr. Creer, you may proceed. Having regard, I've read the affidavit. You may proceed.
As it is the court, my lord, we are of the view that having read the affidavit of Alexander Forbes, the initial approach that we had at section 37C does apply in this matter. And we are going to persuade the court with two case laws with regards to that. The case laws deals with the principle of contra bonis mores, which is concerned with contracts which contradict public policy or recognize notions of Roman Dutch law and English law. How far the opinion the key to one is the key to the other. My lord, we want to submit to this honorable court that we have read the affidavit. What we saw is that Alexander Forbes failed to deal with exactly what the court had requested him to do. Instead, what they have done is an issue of failing to deal with substance. They have grazed over the matter. They have not dealt with the matter itself. They say that it is governed by the Annuity Act. My lord, we have had an opportunity to peruse the act. Nowhere is the court referred to that act where they contradict each other. They don't refer this court.
What act is that, Mr. Sabui? I can't remember an annuity act.
The Long-Term Insurance Act.
Okay.
Yes. They have said that they are referring the court to the Long-Term Act. And what we have done, we also did the homework. We went to deal with the Long-Term Insurance Act of 1998. There's nowhere where they referred the court in answering their documents to that act. They should have said specifically which document, which section of the act are they referring to. They have not done so. But what is quite unfortunate on their side, my lord, is that if you look at the document that they have attached now, specifically the document that they have attached in answering that document, it does not include the very same section 5 of which forms part of their policy, which deals with section 37. And why they do that, we don't know. The one that we submitted to you as the applicant, it deals specifically, it has mentioned in the policy, which the court has said there is contradiction. We have mentioned that. It is in there. But if you look at the document that they have given it to you, which they have given to the court now, they have not done specifically so. And for that reason, we are saying, my lord, they did not respond to the question that this court has requested them to respond to. And as for that reason, the matter should be read in line with section 87C, in that it automatically trumps the income tax. And my lord, we are definitely putting the court with the last word. But then, my lord, there is also one key matter, which is a constitutional court ruling. The constitutional court ruling. My lord, I will address you with the constitutional court ruling. That is in the matter between Betika 231cc, Betika 322, but let me refer to you as CCT 10919. This matter, it was in a constitutional court. It was definitely addressed by Justice Kapembe. I will pick only some of the issues there. It also deals with contradiction where there's a contradiction of contracts. It was said in the final analysis, in conclusion, that this approach is important for the lack of advocating our law of contract based on a framework transformative constitutionalism. And as set out in the second judgment, the recognition of an underlying moral or value choice. The traditional individualistic approach to the law of contract is one that promotes self-interest and self-reliance. This results in the iconic rules of certainty and contractual autonomy to the exclusion of the underlying moral or value choice, which fails to address constitutional transformation. This matter also appeared in the second phase in Bakken that needs to be critically analyzed in this case. The implementation of eviction order for the failure to notify the renewal of this agreement must be weighed against the context already described. Its implementation must be weighed against the principle of fairness and Ubuntu, which provide for a more expansive analysis, which will include inequality in the bargaining power. My Lord, we addressed this court this morning that if you take, for example, the contract of Alexander Forbes, it's a bargaining power that they have in authority. Now, what we find and what the court has already indicated in its sitting last week is that there is contradiction. In other words, what this court has to depart from, they have got to depart from the spirit of Ubuntu, which will indicate the issue of fairness. Now, the issue of Ubuntu will place the reasonable person in the presence of the deceased. To say the reasonable person in the presence of the deceased, will he have been in a position to nominate the respondent at the exclusion of the other beneficiaries who are dependent? Our law is very broad, my God. It's very broad because it doesn't end with dependence. It also goes with an extent of maintenance. It goes deeper even to the maintenance of grandchildren. There's a reference to case law. There was even a ruling by the court where it ordered that a 56-year-old who could not manage himself should still claim from the estate of his father or from what is available from his father. So we are saying, my Lord, the issue of contra bonus mores and also the issue of contra preferentum should then apply in line with the case law that I have submitted. But my Lord, we also have an issue here. We also have an issue. It is respectively submitted that Section 37 of the Pension Fund Act applies to the death benefits derived from the living annuity, where that annuity was purchased with the proceeds of the retirement fund. The legal character of such proceeds does not change merely by virtue of annuity structure. The protective regime of the Pension Fund Act, and specifically Section 7, is triggered where the source of benefit of pension fund is governed by the Act.
Where
now,
are you, Mr. Sibui, sorry, where are you reading from?
The applicability of Section 37 to living annuity purchased with retirement fund.
Who is the author of that which you are reading?
So, yeah, it's paragraph 7 of the list. We did submit this to you.
Thank you very much.
We did submit this to you.
But now, just remind me from your heads. It's difficult to get it on this computer now. Remind me from the heads. What is the author? What is the origin of what you have referred me to now?
Yes. Yeah. As the conference for reminding me now. What we know, my Lord, is that...
No. First, just you read me something. What is the source of what you read me? I just want to make a note of that.
No, the source is Section 37.
No. I know you did not read the section. You read a conclusion somebody read about or wrote about the section. What is the source of what you read me? You said it's in your heads of argument. It will be too difficult to find it now.
Okay. Yeah, my Lord, thank you. It emanates from the reply. It emanates from the reply AF1. AF1, which Alexander Forbes has submitted in the answering affidavit.
So what I can do is I can go to RF1 and read what you told me now.
Yes,
Thank you.
Because it goes further at AF1. It deals with the terms and conditions of Alexander Forbes' retirement income solution living annuity. And I draw the court's attention to clause 18 of the police, which is titled governing law. The clause reads as follows: this policy is governed by the law of the Republic of South Africa. The main legislation applicable to this policy is listed below. Please note that there may be other applicable legislation which is not listed. And then it starts, my lord, it talks about collective investment, financial advisory intermediary, financial markets, long-term insurance 52 of 1998, and then it also lists the very same section 87.
Thank you, Mr. Sibui. I get that. The issue I want to raise with you is that Alexander Forbes in their own affidavit says that some of these funds are pension funds. So there was an investment. Some of the funds that is in the investment constitutes pension funds. Is that not so? Did I read it?
But my lord, we are happy with it because if the court is with us on that one, we are saying where is the genius of the money? Because what we are concerned about here, where is the genius of the money? The genius of the money is pension.
So is it common cause that the money came from the political office bearers pension fund? It was pension money which was paid at a tune of 7% divided by 12 of monthly income. It was then transferred from there as pension money to Alexander Forbes. And from there it was invested with Alexander Forbes in some kind of portfolio which consists of banks and interest bearing and so forth and so forth. And from that pension amount, an amount of 150, an amount was to be paid to the late Mr. Mabuza as a pension or as an income derived from the fund. Is that how I understand Alexander Forbes' affidavit?
Yes. It is like that, my lord, and that's where we stand in and we stand firm.
So the character of the money changed, morphed from pension monies to a normal investment and life insurance policy. That is how I understand it morphed, it changed.
Yes, that's how they say it. And we are saying the money, the genius of the money is what will describe the position of the court. Because it is retirement money, it is pension money. Now, what Mr. Mabuza has worked and lived for, it is that money. So even if it has been moved to any other source, fact of the money is it is retirement money, it's pension money. And as a result, it must be governed by Section 87, which it then trumps their argument that it is not pension money. And above all, my lord, there are decided case laws. The good thing is that there are also decided case laws where the court has overruled, even if that money was policy money or it's annuity money. The court has come into a situation where they have made decisions. We have raised that with Mozilla last time. We have raised a matter with Mozilla, which is a constitutional court decision, where the court overrides. The court does even go to override a will, as long as it is in the interest of justice. So here, my lord, it's a consistency of the law. It's a consistency of the Constitution, which is a supreme law. And then we are driving the court to say, my lord, the court has got an inherent lawmaking. It is not true. Why is the legislation make the law? But the court has got an inherent lawmaking, and the court has not been shy in the past to do so. In this sense, the court has got an inherent lawmaking function to ensure that the beneficiaries are not excluded in line with the Bill of Rights. And also it's in line with Section 27 of the Constitution.
Mr. Sibui, sorry to interrupt you. So you are saying that the pension money changed from pension money to another kind of investment that is supported by a long-term insurance policy. That is the argument of Alexander Forbes. So by doing so, was the entire intent of the Pension Fund Act, namely to provide for beneficiaries, that is people that are dependent, not circumvented by the scheme?
Yes, madam.
So what I'm concerned about is this, that pension money was always pension money while Mr. Mabuza was still employed, and then he retired. Then he made an investment. Now that investment changed from a pension fund kind of investment to a normal investment. So the ultimate purpose of the money, the purpose and the vehicle was changed to something else. Are you saying that by doing this, the provisions of the Pension Fund Act, which has a social purpose, was circumvented?
That's our submission, my lord. That's our submission because in their own governing law that we have read now, the governing laws that they have, it lists Section 37.
All right.
It lists Section 37. It is their own governing laws. It is their own governing laws.
Mr. Sibui, I get your argument. I'll hear from the second respondents' council how they see it. We will engage, but while you are on your feet, just address me on this issue procedurally. Procedurally, I have an urgent application before me consisting of a Part A. Then there is a Part B. Let us go to the notice of motion. Let us just go there and let me just get clarity on this.
Once this lordship is going there, I'm persuaded to read something before it goes there. Before we go.
Let's just wait. Mr. Kitsani, I don't have internet here. Just a moment, I just want to get internet connection here. Because this thing works on internet, you know. I will quickly have to adjourn. I apologize for that because I have no internet connection. I apologize. Let Mr. Kitsani just assist me to get internet running here. I need to go to the notice of motion because there's an issue I want to explore with you. Thank you. Court adjourns for a few minutes. Thank you. system does not want to go from here. This computer, you see? I don't know why. Okay, all right, let me read here. Thank you. Thank you. Just sort that one out. Okay, Mr. Sabine, thank you. Sorry for the inconvenience, but there my computer goes again. Luckily, I have a registrar with a tablet.
Yes, it is for an application for interim relief.
Yeah, it is called in the notice of motion interlocutory relief, but that is more procedural. What you are actually asking is interim relief pending finalization of the final relief, which is contained in Part B. Am I correct?
My lord, you are correct. And can I expand?
Just a moment before you expand, I will give you an opportunity. I just want clarity in my mind. All right. The second prayer in Part A is that the second respondent is interdicted from paying out the money anywhere. Am I right? Just to put it in plain words. Yes. Prayer 3 is that the money must stay in an interest-bearing account.
My lord, like you said,
yes.
I will address you.
All right, and then that the second respondent, that is Alexander Forbes, be ordered to pay reasonable interim maintenance to the second applicant in 127,000 for the year's study and 40,000 per month. That is prayer 4.1, not so? All right, then there's a costs prayer. Part B, look, as I understand the scheme of the notice of motion, Part A is for interim relief pending finalization of Part B.
Yes, that's how it was initially.
All right. Now, Part B, paragraph 4.5 reads that declaring the nomination of the first respondent as sole beneficiary stayed pending finalization of Part B. I don't understand that prayer because it is contained under Part B, whereas it should be under Part A.
Thank you, Madam. One thing that we are going to bring to this honorable court that we feel that it has been a disservice to us. My Lord, when we requested documents from the first respondent, which they are the bearer of the nomination or any document. My Lord, they never gave us any.
I understand that, but
so when we came to this court, we did not have any inside information with regards to any documentation.
yeah, but that's not the issue. It's the wording of paragraph 4.5 of the notice of motion, which says, declaring the nomination of the first respondent as the sole beneficiary of the deceased living annuity be stayed pending finalization of Part B. Should that be under Part A? That's all I want to know.
That's why, through leave of the court, having got the understanding through the discussion and everything, that's why, my Lord, we have submitted with our court order or court order for the court to consider, and whatever is there which should not be there, the court has been given an opportunity through the alternative relief. I definitely agree. I'm with the court on that one.
All right.
It should be impacted.
So it requires an amendment of the notice of motion, not so, in terms of the provisions of Rule 28, not so.
Yes, it may be so, but the issue of the alternative relief, my Lord, the issue of the alternative relief covers that. And in certain appearances in court, the court did not shy away as long as it looks into the substance. 6 to 8 to ensure that whatever has been prayed for is altered. So in line with that,
Yeah.
I would therefore submit that.
Yes, I understand, Mr. Bui, but if that is the argument, there would be no reason for a procedure like Rule 28 because it notifies other parties that are involved that an amendment is sought. Just a moment. Let me hear from the other parties. Mr. Creer, do you have any problem that the notice of motion, Part A thereof, be amended to include paragraph 4.5 now under paragraph B as the last prayer or second last prayer of the Part A? Any objection? Thank you. Ma'am, any objection? Do you want us to amend the notice of motion like that, Mrs. Bui?
Yes, please.
Amendment is granted. Right. Now, let's proceed. Mrs. Bui? Just a moment. I'm not finished with the notice of motion. Okay, paragraph 4.6. That the decision to allocate 100% of the death benefit of late DD Mabuza to the first respondent be reviewed and set aside. I need you to explain to me that prayer. Remember, what I may grant as interim relief is dependent upon what is sought as final relief, because you cannot ask for something as interim relief that is totally dissociated with what you ultimately ask as final relief. Are you with me?
My Lord, I'm with you, and I will submit to this honorable court that we are ready now, more especially because we argued Section 37C. If the court grants us Section 37C, agrees with us that Section 7C is applicable, that submission of a prayer, obviously, I've got no problem in the court taking that.
No, that is not the issue. Look, I'm here to deal with Part A of an application that consists of two parts.
Yes.
That is a Part A and a Part B. Part B, the pleadings are not closed yet, am I right?
You are very right.
So Part B, which deals with the things that I read now, must still be made ripe for hearing, am I right?
Yes.
All right. Now, I don't have to look at paragraph 4.6 under Part B to determine the outcome now, because it must still be determined after all the papers have been delivered, am I right?
You are.
All right. The only reason I have to look at Part B is to see if there is a reasonable prospect of success in order to grant Part A. Are you with me? All right. I read in your affidavit in response to Alexander Fox's affidavit that you are actually praying in the last paragraphs thereof for the relief in Part B. Is that your position?
The court may assist me with regard to
Yeah, please go to your affidavit in response to Alexander Fox's affidavit. Look at the last part thereof where you list what you want this court to grant.
is 4.6.4 that the extent that clause 5 of the annuity agreement creates any ambiguity, the clause be interpreted in favor of the application of Section 37C of the PFA in accordance with conduct of parental rule.
There's more prayers that you list there that you want this court to do. Just read it for yourself, and then you just can relate it.
That it is declared that the board or administrator responsible for the distribution of that benefit must act in accordance with Section 37C, and the exercise its discretion to allocate the benefit equitably among the dependents and or nominees as required by law. That it be declared that the benefit payable under annuity does not fall under the regulatory scope of Long-Term Insurance Act of 1998 for the purpose of determining the distribution of that benefit. that it is declared that the living annuity purchased with the deceased pension fund proceeds falls within the ambit of Section 37 of the Pension Funds Act.
Thank you, Mr. Bui. Thank you for reminding me. That's exactly what I read. So, my question is this. Can I ever possibly grant what you're asking there if that is actually part B of the application where all the parties must still deliver affidavits?
My Lord, the main issue here, which will satisfy us, of all the prayers, it is an interdict. What we are here, which was prayer 2 in the main. What we are here is that what made us to rush, spring, and all of us together with the respondents agree that there's a need to approach the court through Section 84. Is that the money must be interdicted from leaving Alexander Forbes to Momentum, which already that money was disinvested.
Yes,
and
right.
If you look at Alexander Forbes, even today in the reply affidavit, they say they have got no any other alternative but to pay the money. In other words, if we leave this court today, with the court not having granted the interdict, then the money is with Alexander.
All right, I've got that. So that is the urgent need. But you know that it is important to determine what this product was, and that falls under Part B more than under Part A. And how can this court then order payment of 127,000 and 40,000 per month if that will ultimately perhaps be the duty of the trustees? How can I absorb the responsibilities of the trustees and perhaps benefit one beneficiary over the others just by court order?
My Lord, that has been addressed by our prayers of 37C. The prayers of 37C says the money will remain at Alexander Forbes, and it is money that belongs to dependents. Because if you look at the documents that we have now, which we did not have, as I've indicated, my Lord, which I will then also ask, obviously, the court to come to our assistance, is that at the time when we made an application to court, the documents that has only been made available by Alexander Forbes was not given to us. Because what they said at the time was that through the Copy Act, they are not going to give us a document. But what they said at the time was that they have been nominated, the money belongs to them. So, my Lord, if you look at 37C does not deal with Part B. Because 37C is clearly indicating that the moment the court rules, then the tracing of dependents will then be
I understand that.
So based on that, Part B, it does not have an influence here, because Part B will mainly deal with the estate. Part B will concentrate on the estate, but Part A, which is today, will deal with the issues that deals with the day-to-day maintenance of the people that are dependent. So we are saying to this honorable court, we are praying to this honorable court that the moment the court rules today, it interdicts the money. Then the work starts, because the work starts by tracing the dependents. And when it starts tracing the dependents, it will then determine how much is going to be paid, because that issue of 40,000 and the issue of 127,000, the court has already raised that in the last sitting. And we have responded in the transcript which we have attached. We have responded to say we are with the court. It will not be for the court to determine that 127 must be paid to the university, but it will be for the trustees to sit and determine that. And also, the issue of Part B, as I've indicated, is not influenced, my Lord, by Part A, because once the court agrees that Section 37 applies, then the work starts.
You see, sorry, Mr. Sibui, before you go on, this is the issue. Today you want protection of the money, am I right?
Yes.
All right. Does any of the parties have a problem with that, Mr. Creer? That the money be protected pending finalization of Part B?
Well, that's the whole argument of the first respondent side is that
Mr. Sibuye, may I proceed? Sorry.
Yes,
sorry.
Mr. President.
section 37 of the contract is not for investment and that the money should go.
All right, thank you, I've got you. Thank you very much. Mr. Sibuye, anything else? Any other argument?
My Lord, at the time we wanted to read, except as provided for, it says, except as provided for in Rule 6.4. The pension of each member who becomes entitled to pension in terms of Rule 5 shall be purchased in his or her name from a registered insurer of his or her choice. The member may choose to purchase multiple pensions if she so wishes. The terms and conditions applicable to any of each such pension, including options elected by the member, and the determination of any benefits arising on his or her death, shall be that is compulsory, commutable, non-assignable, payable to life, and shall be subject to the provisions of the Act, and any requirements of the revenue authorities, and where applicable, shall be set in writing by the registered insurer provided for.
Thank you,
And
Mr.
then
Sibuye.
the act that I wanted to emphasize, it is pension fund act.
Yeah, I know
So
that.
annuity-
Thank you, Mr. Sibuye. Anything else?
My Lord, can I then take you again to a document which we have attached? It's under. My Lord, 002 stroke dash 56 or 655. I want to refer the court to that document. This was a communication between Mr. Mabuza, assistants, or the main person responsible at Alexander Forbes. It was written by 11 September 2025, and it referred to Mr. Mabuza's ID number. It was written by Mabuza's daughter, Lingane. And the purpose of that document was to check with them as to where are they with regards to the distribution of the fund. But we find here, to the Honorable Court, it's written by Andrew Leventis, who is from Alexander Forbes. Dear Lingane, thank you for the chat yesterday and for giving me information about your family. I understand you are going to the Master's office on Monday. I've attached a recent statement of your late father's living annuity, which shows full name of the beneficiary. We had a recent discussion with David. David refers to the deceased. And he wanted to change the beneficiaries, and we did send in the paperwork to do so. He mentioned he wanted to nominate children. And I said all we needed was details of the children to sign a beneficiary nomination form, which we sent to him. His PA, Lerato, knew about this. I'm saying it is very important for me to submit this to the Honorable Court, because, my Lord, the person who wrote this is the main person responsible with the fund at Alexander Forbes. And this person does clearly state to us that during the time, or at the time, when when the late Deputy President of the country was alive around May, because the communication seems to take place around May, then there was communication and intention. And I'm tempted to draw the court in terms of the interstate succession law, although we will say it's not applicable here. where it is said, if there is a will that has been drafted, and then you find that in the will, not everything has been completed, and in the will itself, it has not been signed, the court can insert the wishes of the testator.
Yeah, you see, there's Mr. Sabri, there's a specific act that that provides for that. It's fine. I don't concern you too much about that because Alexander Forbes has attached to their papers forms that was completed by the late Mr. DD Mabuza to change his beneficiaries substantially. But apparently not everything was completed and therefore the change did never take place. Alexander Forbes was forthcoming enough to disclose that to the court. So you can accept that I accept that he wanted to change his beneficiaries, but it never materialized.
I'm very happy.
Anything else, Mr.
Yeah, my Lord, I definitely want to close my argument by saying that we have submitted whatever we have to submit. We still submitted to this honorable court that the ruling of the court that there is contradiction within the document, the policy document, and the nomination form of Alexander Forbes still stands. It has not been addressed. And further, that the issue of the form in substance, AFRIS LA certificate expressly refers to a retirement fund income solution, living annuity fund, with fund registration number. By using a pension fund terminology and presenting itself as a fund, the product assumes the character of pension provident fund, a benefit, not a pure insurance policy. Courts look into the substance and the purpose of the product, not merely its label, as illustrated in S versus DPL in 1978, stroke 2 SA 140T. In integration with the retirement, the living annuity in this case was pursued with the retirement fund structure and directly with the private insurer by three shows. If the proceeds came from a retirement savings regulated by Pension Funds Act, then the obligations under Section 37C should remain applicable and safeguard independent. It is on that submission that, my Lord, even if the Deputy President was of the view that he wanted to exclude his children, the law, Section 36 limitation clause doesn't allow him. Section 36 clearly spells out that any decision has to be reasonable and justifiable. Now the question is on reasonableness. Was he reasonable enough to exclude these kids? The answer will say no. Was he justifiable in doing so? The answer will say no. Because the dependents are here, they are alive, and the court remains the guardian to ensure that those dependents and even grandchildren, it extends to that. The law has ruled in favor even of grandchildren.
Thank you, Mr. Bui. Mr. Creer, any argument? You may proceed.
In respect of the position of Part A and Part B, one looks at the position of Part B. My submission that there is no problem for success in that, because there are no trustees applicable in this matter that can distribute the money which is currently in dispute. It has to go to the sole nominated beneficiary in this instance, as explained by the second respondent in the affidavit as well. So one looks at the relief sought in Part B, my lord. What is asked for, that it be distributed in terms of Section 37C of the Act, which our submission is not applicable. It's still a contractual relationship, there's no fiduciary relationship between the parties, and therefore Part B of the application of our Part B.
Thank you, Mr. Creer. Anything else?
No, my lord.
Thank you.
Already made our submission.
Thank you. Good man. I want to know from you, what does the affidavit mean when it says that some of the funds are still invested in pension funds? I read that in the affidavit, or did I read it wrong?
My lord, I'm continuing to go through the arguments that I've done in my...
No, I want that answer. You can then address me on your argument, but that is the first thing I want to know. The question is this: did I read correctly in the answering affidavit that, or the explanatory affidavit, yes, so thank you for that, that some of the funds are indeed in pension funds?
My lord, I believe you may have understood the point incorrectly.
Or I just read from the affidavit where that amendment is made. Quickly find it and then you read it for me. I'm asking you because I don't have my computer. Here it comes. So let's look together. You look for it, I will look for it. Thank you.
My Lord, if I may just ask, is the document that you're referring to the attachment that would be extra A?
No, I'm talking about the affidavit itself. The affidavit, explanatory affidavit itself, I read it there. I must have understood it wrong, or you must tell me if I did.
I'm unable to locate a portion of that affidavit that says that there is a portion that is correct.
All right.
It is, however, as I'm trying to state, a portion of the affidavit that deals with the investment statement, and that deals with various products.
All right, I've read that. What is your argument?
So, with relation to the investment statement, which my learned friend agrees on behalf of the applicants is a policy document. Principle that this is an investment statement. It's just a statement that gives the client, in this case Mr. Mabuza, information about where his fund stands and a statement of account as to what has been happening with various funds that he has here too.
But it goes further to say what happens at death.
It
You
does
cannot
also-
delete that. That is on the statement. It goes further.
So, my Lord,
So why is that on the statement, and what was the thought in the mind of a reader of such a statement if on the statement where a person that does not presumably know investments, therefore you go to an advisor, reads on his statement that this will happen on death?
So, my Lord, if I may refer you to the extra AFP,
Yes.
because I believe it's necessary. There's a table at page 1.5 as 002-278. It contains a table that has all of the products that are administered by Glacier Partners. There are 4 types of products here.
Yeah, but we are not there. We are at a point where I know that the money was invested with Glacier in different funds. I get that. You don't have to refer me to the table. What I want to know from you is why is the death benefit payable printed on that very same statement, and what would happen in the mind of a person that has little knowledge or seeks advice about this if he reads this on the statement?
So, my Lord, the solution that I'm trying to make is that if you go below that table to find the very place where the contentious paragraph is clause 5, retirement funds. That paragraph that is of the nature of contentious is labeled death benefit preservation funds. My Lord, what I was trying to submit, if you would allow me, is that if you look at the table, preservation funds appear under registered retirement funds. They're administered, the custodian is a registered retirement fund. There are 4 such products, and I've named them in the explanatory affidavit. The intention of the general terms, whilst I may admit are not necessarily examinationally written,
Okay, so sorry to interrupt you, was some of the funds invested in those 4 authorized pension funds?
absolutely not. It's a general set of terms that applies to all of the products that are said. The idea is for a client, as with within advisor, Mr. Mabuza at all times had an advisor, Mr. Andrew, as the applicant's counsel has said. He would then know, reading the policy, that if the document or the term of the document that contains general terms for all of the products that are applicable to horizontal folks, that retirement funds can only refer to those that are administered by a registered retirement plan. The product that Mr. Mabuza had taken was, in fact, under a long-term insurer you'll see it on the far right column. It would be the first one appearing under that portion of the table. It is the AF Retirement Income Solution Living Annuity. He would know this in consultation with the advisor that he would have had, an example folks, that his particular product is a long-term insurance product, and therefore any term that deals generally with retirement funds or preservation funds, as appears there, was filed is not applicable to the contract that he has taken. this is a contractual arrangement, it's an investment product, whereas that section, that portion that is labeled retirement funds actually deals with retirement funds as would be, well, not defined, but set out in the table above. And so it's a key option to understand where your product is and which terms will apply to you. I submit that in relation to Mr. Mabuza's product, which is the AFRIS living annuity, there isn't a general term that is applicable to him because all of the terms that are applicable to that contract are fully contained in the policy document that is attached at AFR. So there was no ambiguity that would have arisen in him, and this would have been a conversation we would have had and advice we would have received from his financial advisor. So we submit, because of that amount of expenditure, that there isn't an ambiguity, certainly not one that would have arisen in the mind of the deceased. He would have been clear about this, and to the extent that there are clear terms in Annexure AF1, which is a policy document, the terms that specifically speak about what should happen on the death of a client are contained in clause 8 of that document, and not in the general terms that are contained here. This is just a monthly statement, not a monthly, sorry, a periodical statement that he would have received from time to time when he would explain with his parents' name, and he would have understood that he would only refer to the general terms at the bottom of the key insofar as they refer to his product, which they didn't.
Thank you. Anything else?
There is no
Thank you. Mr. Bui, a reply. I'm going to give you 5 minutes.
My Lord, I refer to you that I refer to the Honorable Court to the investment statement, which is part of the policy. The letter that was addressed to Mr. Mabuza, dated 30 May 2023, which also formed part of the AF1, specifically states that investment statement that will be sent to him from time to time are also part of the policy schedule. It is therefore incorrect for the second respondent to state that the investment statement is not a legal document. It forms part of the legal document. The argument of the above clause 5 of the investment statement, which has already been referenced in the founding affidavit, makes specific reference to section 37C of the PFA. This reference creates a reasonable expectation that the benefits payable under the policy should be distributed equitably among the deceased dependents and nomination in line with the principles set out in section 37 of the PFA. Even if the policy were to be governed primarily by the Long-Term Insurance Act, the express reference to section 37 introduced an element of ambiguity. In such cases where two legal frameworks appear to overlap or conflict, the interpretation should favor one that upholds equitable principle, in this case the PFA. My Lord, that is our submission with regards to what she has raised. In her own submission, she says Mr. Mabuza should have known. Mr. Mabuza should not have known. Mr. Mabuza should have been assisted by them, not that he should have known. If you sell a product, you should be able to explain point by point to a person taking that policy. But I've already answered, my Lord. There's no reference to the act that they are relying on. There's never been a reference to the annual to the act that they are referring to. So basically they are just arguing from the air. We have got documents, my Lord. This is a document which comes from Alexander Forbes, and in the light of this, I definitely would want to persuade the court to rule that this policy falls within the 7C. And my Lord, I also want to address you on the issue of cost whilst I'm still. The issue of cost is very, very important. The last week, Tuesday, when the matter came before this honorable court, the ambiguity was raised by the court. It's in the papers. There's ambiguity in their own documents. Alexander Forbes should fall on their laurels. They need to pay the cost on attorney and client scale for last week. My Lord, it's my submission again that today, in today's proceedings, Alexander Forbes have got to bear the cost for today's proceeding on attorney and client stage, and that will include again the first respondent. Because the first respondent, my Lord, when we initially started the process, it was not our position that we needed to come to court. We came to court as a last resort. We have entered into negotiation, discussion about this whole issue. There is even, although I don't have to go to part B, but there has always been discussion between the parties on how this matter should be resolved amicably and can be resolved amicably. Until today, my Lord, my learned colleague stands in here despite the fact that the court has raised the issue of ambiguity. He stands in today here and says to the Honorable Court, Section 37 does not apply. The main issue for saying it doesn't apply, it's obviously self-greed. It's where someone stands in and say, I need to benefit 44 million. 0.7 at the exclusion of the dependents, which they know, and they know that the law will always rise when it comes to the issue of dependents. They violated the Bill of Rights, they violated Section 28, the issue of security to persons. They know that it's a social contract that exists between the deceased and his own dependents and children. And dependents does not only look at children. It goes further because Mr. Mabuza also had a family that he was also looking after. So they come in here, they want to reverse the money. It is my submission, my Lord, that they have got to pay the cost on attorney and client scale.
Thank you, Mr. Sibui. I need to hear from counsel for the second respondent about costs.
Well, the submission of our costs comes as a bit of a surprise. I submit that at all times, Alexander Forbes has not opposed this matter and has steadfastly stated that it will abide the court's decision to the extent that we are here and have filed an explanatory affidavit simply to come to the court's assistance in clarifying what may have been received as...
I understand, but it is as if you are, Alexander Forbes acted like Pontius Pilatus, I don't know, to wash your hands and don't care, because there is a big dispute about 44 million rand amongst family members. And what concerns me is that you, as a company who obviously advised the late Mr. Mabuza, now come to court first and say nothing, and then you say you abide. It is like, we don't really care. Isn't it so? Or is my thought about this wrong?
I cannot agree with that
Oh.
postulation, but I do not believe that Alexander Forbes has washed his hands of the situation. I believe that the case is a contentious one, and there are interests on both sides that are very important interests, and we do not sit back, but knowing the position that we have based on the contractual arrangement we have with the deceased, we found that it would be better not to oppose the reducement, but to rather ensure that the court can give a decision based on what...
Yes, but I had to prompt you to help the court. I had to ask for affidavits. This matter could have been disposed of last week if you did what I am of the view the right thing, to give proper information to the court about the product that your client sold.
I understand that.
Thank you. Mr. Creer, costs?
Yes, the court would have noted from the start of the first respondent that we have asked for cost on punitive scope. The court should follow suit. With regards to perhaps the waste of costs, the court would communicate to the second respondent that provides some clarity on certain issues that is come down to today. Still must be costs should follow suit.
Thank you so much. I'm going to give judgment just now. I've heard lots of argument this morning and I have to apply my mind. So please bear with me My registrar will let you know when judgment will be ready. Thank you so much. Court adjourns. Living Annuity Fund, registration number 19970000515/06, with investment portfolio of risk investment number RIS 04842LA of the late Mr. David Deputy Mabuza, ID number 600825588489, pending finalization of Part B of this application. 3. That the annuity funds presently held by the second respondent be retained in an interest-bearing account pending determination of Part B. 4. That the respondent be directed to pay such reasonable interim maintenance for the support of the applicant's child as this Honourable Court may direct pending finalization of this matter. That the second respondent is directed to pay an amount as follows. Paragraph 4.1.1 127,990 rands of tuition of the second applicants every year, 40,000 for the second applicant's monthly maintenance including basic necessities including clothing, transport and medical expenses. Paragraph 4.2 directing that the first respondent to grant the applicants and the deceased dependents reasonable access to the family home in Barberton, Mpumalanga, where the deceased was buried, for the purpose of exercising their cultural and family rights to visit and tend to deceased's grave, and then there's prayers regarding costs. Paragraph 4.2 was not argued because I was informed that that no longer is an issue. So the issue that I had to decide is whether or not to grant this interim relief pending finalization of the main dispute, and that is Part B of the Notice of Motion. Part B reads as follows. 4.5. Declaring that the nomination of the first respondent as the sole beneficiary of the deceased living annuity be stayed pending finalization of Part B. Let me just stop here. Clearly, this paragraph was at the wrong place because it seeks interim relief under the heading of Part B, which is final relief. So, when I prompted Mr. Sibuyi, who appeared for the applicants, I was requested to amend the notice of motion. The other parties did not object to that. So, this paragraph 4.5 will now fall under Part A of the notice of motion and therefore read, declaring that the nomination of the first respondent as sole beneficiary of the deceased living annuity be stayed pending finalization of Part B. So the interim relief that I had to consider was pending the final dispute, and that is in paragraph or Part B of the notice of motion. I've inquired from the parties and Mr. Sibuyi in particular that the papers in Part B has not closed yet. By that I mean that all the evidence that forms part of the relief sought in Part B is not before the court. What the court has before it is the evidence for consideration of Part A, together with the evidence that I requested to get certainty over certain things from the second respondent, where the matter was heard last week Tuesday. But let me explain or read Part B so that the connection between what is requested in Part A can be understood against Part B. Remember, I said that Part A is an interim measure to retain the status quo until the main dispute, which is Part B, is finalized. Paragraph 4.6, that the decision to allocate 100% of the death benefit of late Ms. DD Mabuza to the first respondent be reviewed and set aside. Declaring that the annuity constitutes a patrimonial asset or financial resource of the deceased which must be made available for the benefit of his dependents. Directing the second respondent to distribute the proceeds of the annuity equitably in accordance with Section 37C of the Pensions Act among all lawful dependents of the deceased, including the applicant's child. 4.9. Alternatively, and only in event that Paragraph 4.4 is not granted, directing that annuity be retained pending an inquiry into the deceased dependents and their needs, with liberty to any interested party to approach this court on supplemented papers. I need to stop here. Reference in this paragraph to paragraph 4.4 above is incorrect because paragraph 4.54 is in part A. I presume that this reference to paragraph 4.4 is actually paragraph 4.6. But that is just a side. We get the notion of what is requested as final relief. 4.10, setting aside the posthumously issued marriage certificate obtained by the first respondent, cost of suit in the estate, granting further or alternative relief. There, the full picture therefore emerges. The ultimate dispute is what must happen with the 44.7 million rand. Must it be distributed in terms of Section 37C of the Pensions Fund Act or in any other manner? That is the ultimate dispute. Together with this dispute, which I have identified when I engaged the parties when the matter started, the simple dispute is the following. Whether or not this transfer of the monies was in terms of Section 37C of the Pension Funds Act, or did the money go and was it invested into a kind of investment where any person can nominate any beneficiary it likes? Because there are strict rules when money is invested in a pension fund. Then the trustees of the pension fund has an obligation to do certain things and to distribute the money fairly amongst those people who need it the most. It must investigate the situation. When I heard the matter last week Tuesday, I was concerned about discrepancies between the policy document. Let me call it a policy document, but as a matter of fact, it constitutes an agreement between Alexander Forbes and the late Mr. DD Mabuza, and the statement that was given to him. The question that arose was whether or not this investment constitutes an investment in terms of the Long-Term Insurance Act, for then the Income Tax Act applies and a person can nominate the beneficiary. It's your choice. You don't have to account to anybody. Or is it an investment in terms of Section 37C of the Pension Funds Act? Because then you can nominate the beneficiary, but your nomination will come to naught if there are other people that requires money more. Now, this is the simple issue. Do I grant an interim order to preserve the status quo until the main dispute is decided? In my mind, to decide the main dispute, which is fully encapsulated in Part B of the Notice of Motion, will be premature, because the parties still have to file all their affidavits. The pleadings are not closed. I can therefore not venture into what a court will decide at one time in future without even having all the papers before me. I will not go there. I will concern myself with Part A of the Notice of Motion, which is an interim measure. But here is the difficulty. Part A of the Notice of Motion also requests certain maintenance requirements of the second respondent. And that is tuition fees and also 40,000 rand per month to sustain the second respondent, who is currently at the University of Cape Town and living in Cape Town. So now this is difficult. If the money is indeed invested and the court ultimately finds that into a pension fund, the trustees will have to make that call. The second respondent would have to submit whatever she needs, and all the other respondents should submit what they ever needs, and then the court must make the trustees must make a determination. It is not the court's job to make such a determination if the money is invested in a pension fund. To do so would be premature, because in terms of the Pension Fund Act, especially Section 37D thereof, there is a process. If any person is dissatisfied in the manner in which monies were distributed, they can, in terms of Section 37D of the Pension Fund Act, approach the trustees, and there is administrative provisions to provide for that. So to intervene there now as a court will be premature. The court will have to allow the trustees to first make a call, do their job, and if anybody is dissatisfied, they can use the procedure under Section 37D of the Pension Funds Act to voice their concerns. Therefore, I should be clear that the reason why I requested further information is to satisfy myself about one of the requirements for interim relief. In law, we call it an interim interdict. One of the requirements for an interim interdict is the person that wants interim relief. So the person that wants a status quo to remain must convince the court that there is a prima facie right. A prima facie right is a right that might be open to some doubt. So it's a right that is not finally considered or decided, but there appears to be a right. That is what a prima facie right is. So a person, like in this case of the applicants, had to convince the court that at least there might be some prima facie right they are entitled to for them to obtain an interim interdict. And I had to determine if there is such a prima facie right by requiring Alexander Forbes to give me more information, because I could not determine that only by looking at the discrepancies between the two documents. Unfortunately, after having read the affidavit of Alexander Forbes, I'm not entirely convinced about how this money morphed from protected pension funds to no protection. That will have to be explained, and that will have to be explained in Part B of the Notice of Motion. So the reason why I requested to conclude on this for more information is to determine whether or not there is a prima facie doubt, a right that might be open to some doubt, and I'm transparent in this regard. I still have doubt in my mind whether or not the applicant is entitled to demand that the money be dealt with in terms of Section 37C of the Pension Funds Act, but that doubt does not prevent me from granting an interim order. The main concern of the applicants are that this money, and it was said so by Mr. Sibui, that the money, if we leave the court, will immediately be transferred to the first respondent. Then the money is gone. That is what they say. I need to protect that, but because in my mind there is a prima facie right that this money might be pension money in terms of Section 37C, and therefore it needs to be protected. The other requirements for an interim interdict, I'm of the view, have been satisfied, namely balance of convenience. That is when the court looks at the convenience of a party who gets protection in the interim against the party against whom the interim protection counts. So in this situation, I had to look at the balance of convenience at the interests of all the beneficiaries of the estate against the interest of only one. And in my mind, the balance of convenience favors all the beneficiaries of the estate instead of one. The court also has to look, when it comes to interim interdicts, to an apprehension of harm. And one doesn't have to dig too deep to think that there might be an apprehension of irreparable harm. Because if harm was not imminent, I do not understand how the second respondent could have refused and even oppose this application if there was no intent on the first respondent to keep the money. Otherwise, why oppose the application? That shows me that there through that conduct, although everybody is entitled to oppose relief, but it shows me a certain intent that this money might be gone forever in the eyes or in the hands of the beneficiaries if the first respondent gets hold of the money. Then the last requirement for an interim interdict is that there is no other alternative satisfactory remedy. I think I do not have to dwell on it for too much because I don't think there would have been. There's another remedy. The money is there. It is imminent that it will be transferred. So I don't think that a letter would have sufficed. The mere fact that Alexander Forbes appeared and said they will abide by the decision of the court means that Alexander Forbes might probably have acted on a letter from the first respondent to get the money, because the first respondent is a beneficiary on the fund. So there was no other way for the applicants to protect their prima facie right but to come to this court. I'm therefore satisfied that I am, with the information in front of me and the argument that I've heard, I can grant an interim order to remain the status quo pending finalization of the main dispute, which is what this fund is ultimately. Let me turn to costs. Mr. Sibu argued that Alexander Forbes must pay the costs because they did not want to give information and relied on the Poppy Act, and also was here, and due to the discrepancies in the policy document and the statement, the matter had to be adjourned. I take a different view. My concern is more deeply rooted. And my concern is this, that a company that takes on an investment of 44.7 million rands, well knowing that this money is important money. First of all, it's a lot of money. And secondly, lots of people depend on what will happen to the money. Then comes the court when they see they have been served with the papers. They see that there is now a dispute. And they should have perceived that this dispute, because it's crystallized in the papers, concerns what is this now? Is it pension or is it a policy? They decided to come to court and say they abide the court's decision. I don't think that is the correct manner to have done it. It is as if you cause problems and then you want to turn away and leave the problems to be resolved by other people. In my mind, Alexander Forbes, with respect, could have much earlier seen the problem and given an explanation, instead of coming here and saying they abide the decision of the court. If you take the responsibility of managing so much money, giving advice to people, I think you have more to do than when there is a dispute to just come to court and say, I have nothing to say. Therefore, I think that it is warranted that Alexander Forbes be ordered to pay the costs of last week, Tuesday. I'm not going to order costs on a punitive scale, only because they said they do not oppose the application, but they were here. So I'm going to grant costs against Alexander Forbes on a party and party scale. In the premises, this is the order that's made. The second respondent is hereby interdicted and restrained from disinvesting, transferring, or paying out any portion of the Alexander Forbes Retirement Income Solution Living Annuity Fund, registration number 1997/000-595/06, with investment portfolio AFRIS, investment number RIS 04842LA of the late Mr. David Deputy Mabuza, left bracket 6008255884089, right bracket, pending finalization of Part B of this application. Two, the second respondent is ordered to pay the costs of the applicants and the first respondent occasioned by the hearing of, what was the date on last week, Tuesday? 23rd. 23 September 2025. 3. The parties are hereby directed to approach the registrar of this court for purposes of managing Part B of the application and do so before 1600 hours on 15 October 2025. That is then it. There are two issues that I want to address before we proceed. One is I want to thank Council. It was a privilege to engage with you and to deal with the law and also deal with the facts. I want to, as not part of this judgment, the judgment is finished. I want to ask the Mabuza family, settle your dispute. We have seen so many of these kinds of disputes in courts. You know, I always ask, what would the late person do if that late person was still alive and in this courtroom? Will the arguments have been the same? What would the late person have said? The only thing that remains after all of this happens is scars between family members that never heal or take very long to heal. So my request is, humble request, please see how you can settle this dispute. Because courts are there to settle disputes, but there's always a winner and a loser. No court case, exceptional cases perhaps, have two winners. One loses, one wins. So please settle this. The next thing is I want to thank the staff and my colleagues and all the attorneys of the Mpumalanga High Court. My term as being an acting judge ends today, 30 September 2025. It ends because I have been recommended as a permanent judge already in 2021. But there are parties that are challenging that decision of the Judicial Services Commission. That decision is taken on review. That review was heard by the High Court in Johannesburg and the review application was dismissed. But those parties decided to approach the Supreme Court of Appeal. I am therefore thankful to every colleague, every attorney that appeared before me, every counsel, that we could engage each other. It has been a privilege for me to serve the peoples of Mpumalanga, and in many cases also people of a wider location, because many disputes arise in Mpumalanga, but the parties that are interested in it is all over the country. It was indeed a great privilege. Thank you so much for the time I had to serve the community. Thank you. The court adjourns.